Court of Appeals Division 1 is now in session.
Good morning. Please be seated. You can see that the courtroom has been set up so that we are socially distant. Please feel free to take off your masks if you're comfortable doing so. We've moved the microphones to council table and request that you make your arguments from there in a seated position. That way we can accurately capture your argument for purposes of our video and recording equipment. This is the time set for oral argument in State of Arizona versus James Michael Harries. Our criminal number 18-0520. Each side will have 20 minutes within which to present their arguments here. This morning, appellant may reserve a portion of that for rebuttal. However, it's up to you to keep track of your time in that regard. Hopefully you can see the clocks. They're on the podium. Are they reversed? All right. We have read the briefs. We've been through the record. We've conferenced the case. We're familiar with the issue before us. That counsel, you may proceed.
Thank you, Your Honors. If it please the Court, Craig Rosenstein and Stephen Charbonneau on behalf of James Harries. I am going to ask to preserve at least 5 minutes for rebuttal, and I will do my best to keep track of the time. To start off with the point at hand would be to suggest that Judge Otis lacked authority to grant the state's motion to reconsider. 13604 exists a statutory authority, and that authority affords judges in certain circumstances to make certain felonies into misdemeanors. There is no statutory authority to turn a Class 1 misdemeanor back into a felony and re-felonize somebody. The timeline of events are important in this particular case. I know that there was some consternation. I'm sure, conference didn't gone over it, you're aware of it. But in this particular case, I'd like to highlight just a couple of dates that I think are exceptionally important and focus on a couple of issues at hand. First, it was on August 30th, 2017 that the state filed its motion to dismiss in the 2016 matter. It was that same day that they sent it over to grand jury. There was no notice to Mr. Harries at that point. Obviously, grand juries are sealed and not made with notice. On the 31st, Mr. Harries went on the 2001 case and as a pro per defendant filed the motion that the court, with the court's paperwork, asking the court to designate his 2001 conviction into a misdemeanor. It wasn't until September 5th that Mr. Harries was served by certified mail, and that service, in that service, he was notified that they had refiled under a 2017 case number. Judge Otis on September 22nd granted that motion and designated his felony a misdemeanor. And from that day until the state filed its motion to reconsider, which was subsequently granted in September 22nd, he was not designated felon. He breathed freer air. He was able to walk about with less concerns. He had more rights. And as a result, we'd ask this court to take those dates and that issues into account when passing its decision.
Counselor, would there have been authority under Rule 24 to revisit it, to vacate the judgment? Rule 24, I believe, provides for 60 days. Would there have been authority under Rule 64 to do that?
It's a great question, Judge. The issue in this particular case, and I understand the question, I'm going to answer it in a slightly roundabout way, which I know is sometimes annoying. I apologize. So the issue in this particular case is whether or not a mechanism exists by which the defendant, or by which the court can re-felonize somebody. It's unequivocally clear in 13604 that there is a one-way street. Now, that being said, courts clearly are uninclined to tie trial judges' hands for situations such as mistake and clerical errors, and I recognize that. But in this particular case, the state's reliance on condos and the Arizona Rules of Civil Procedure 60 in particular do not afford them that opportunity. Rule 24 does not, in fact, grant there's no mechanism granting the state to answer the question. Sure.
But it says either party may file a motion in Rule 24. Does that mean the state, it's still a one-way street?
Well, once granted and unfelonized, then Mr. Harries cannot be refelonized absent due process. And that's
Can he be refelonized with due process?
I would argue no, but there would certainly have to be a minimum due process.
Because you consider that a violation of double jeopardy?
Yes.
But I think to Judge Catani's question, had the motions been timely filed under Rule 24.2, it seems that there would have been an avenue for relief, no?
So the fortunate part about our situation is that this court doesn't have to concern itself with that issue in light of the fact that it was clearly untimely. An argument that we present is, in order to even get to the substantive issues, this court has to first address two major issues. One is whether or not there was a timely designation or timely filing. In this case, there certainly wasn't.
But just indulge me for a second.
Sure.
If there had been a timely filing, because we have to analyze all of the applicable law. If there had been a timely filing, there could be some relevance to the rule, but not. Yes?
Certainly, that would be a discussion worth having. I could clearly see arguing both sides of that. I would still say that the mechanism wouldn't exist, but I could definitely see a more vigorous argument for granting leave or stay under those circumstances.
But you would then fall back on double jeopardy and say Rule 24 can't. There are many sorts of relief from judgment possible, but not this one.
Correct.
Okay, understood. Thank you.
And honestly, before we even get to the substantive issues of whether or not the judge had authority, I think it's important to note we have to answer two questions that were raised by the state in their brief. The first is one of timeliness, and I think the state's argument of trying to corral Arizona Rules of Civil Procedure in the absence of any procedural outline here fails for a number of reasons, and we can get into all of those. Condos certainly wouldn't be an applicable analysis, in our opinion.
Could I just ask you, sorry to
Sure.
kind of derail you here, but what, in your view, what issues would the state be entitled to raise, if any, in a Rule 24 motion? Say they file a timely Rule 24. What can they do if they disagree with a redesignation, have a decision to redesignate an offense as a misdemeanor? Can they do anything under Rule 24?
So my initial argument would be no, but. So no, because of double jeopardy issues that would attach. That being said, assuming that we're going to operate under Rule 24 where double jeopardy is, and this court declines to apply double jeopardy if we're inside the timeliness factor of the Rule 24 motion. I would suggest that the state would be relatively limited in its motions. Facts, if there was a clerical error, I think that would be certainly something that either party, the state, could bring to the court's attention. I can imagine a number of different hypotheticals under which
Anything other than a clerical error, though?
The court could, assuming that double jeopardy is not attaching, I think the argument becomes substantially stronger if it's filed within the timelines of the Rule 24 to argue substantive merits. But the problem I have is if we were within the timeliness factor, then we would be arguing at that point the double jeopardy concerns. If the court declined to accept that rationale, then I think within the 24, then the substantive issues come into play. And then it would be the basis upon which the court made its decision and whether or not that was arbitrary or capricious. So in this particular case, once again, just kind of getting back, before the court even makes a substantive decision, I think we have to address the two issues. The timeliness issue, obviously. Condos doesn't apply because condos is a common law remedy, and this is a statutory mechanism. And in this particular case, we have 13604 provides a statutory mechanism by which we can go and approach this particular issue. Condos is only for common law remedies. If we...
Does condos have any vitality at all in the 21st century?
I could imagine a number of scenarios in which condos would apply.
Indeed.
The problem is that in criminal law, there are situations in which direct and absolute procedure for any number of new scenarios are without. So as the state legislature passes new mechanisms for set-asides or expungements, there could theoretically, and not passing the procedures, leaving it to the court, and in that intervening period of time, I can imagine a number of scenarios in which the court would theoretically rely on condos to kind of fill the gap for procedural mechanisms.
Isn't condos essentially tracking Rule 60?
Yes.
And our Rule 24 seems to abrogate any kind of reliance on Rule 60 in criminal matters, does it not? It seems like the comment to Rule 24 specifically says Rule 60 no longer applies.
That would be, yes. I mean, I would. I'm trying to create creative arguments that it doesn't.
You are being imaginative, but I'm not sure my imagination extends that far, because I think as statutory changes alter the impact of rules, our court has proven nimble at either changing the rules or temporarily adjusting them under administrative order or through tools of interpretation of existing rules serving a statutory purpose. I don't see where courts are free 96 years after condos to just rely on their inherent powers to make substantive decisions.
I wouldn't argue too hardly against that, Judge. Lastly, I guess this kind of goes back to the Rule 24 argument, is the state's reliance on the timeliness issue of its motions, all of them based on Rule 16 pretrial motions, would not be applicable in this particular case. And I would certainly highlight that the state's reliance on those particular cases, Vincent, Kramer, and Colvin, are not applicable here, because those are all pretrial matters, mostly inapplicable based on case law and not relevant to the case at hand. I'd like to reserve the remaining time.
Thank you, counsel. You may proceed.
Good morning, Your Honors. Amanda Parker, appearing for the state of Arizona. The state asks this court to affirm the trial court and find that the trial court had jurisdiction and authority to reconsider its ruling. Condos is good law. Condos mentioned that the trial court's jurisdiction and authority to reconsider its own ruling.
How do you figure that condos is still good law?
I think it recognized at common law, so before some of these criminal
all
rules.
Those troublesome statutes and rules, but we have those now. Why wouldn't those be seen as superseding condos? I mean, otherwise, I guess the court wouldn't have had to, or the legislature wouldn't have had to pass these rules and statutes.
I think that, so condos in Rule 60, it was incorporated into condos. In that 6-month time frame that's in Rule 60, I looked a little bit into term of court, and I think historically courts used to sit for 6 months and then go on vacation for 6 months, and so that the time frame in condos is basically embodied in Rule 60B.
If you'll excuse a civil analogy, it almost sounds though like arguing what the summary judgment doctrine was before Ormschool, or what the peremptory strike doctrine was before Batson. I mean, at some point, the relevant authorities issue new law. Aren't we bound to follow that?
Are you referencing Rule 24?
Well, Rule 24 would be one way, because as we discussed with your colleagues, had there been a timely filing under Rule 24, at least there would have been a vehicle to get this before the court. Whether constitutional concerns come into play is a question I don't think we have to deal with today. But wouldn't Rule 24 have given an opportunity to the state if the motion had been timely filed?
The way I read Rule 24 is that it applies to judgments, and I'm not sure that the order at issue in this court or in this appeal would constitute a judgment. It's certainly an order.
Well, but how could it not be? Isn't it the final proclamation of guilt? In other words, you're guilty now of a misdemeanor, not a felony. That's a material distinction, and this is the only document that does that. How could that not be a judgment?
The judgment of guilt was back in 2001, and the sentencing was concluded, and I think the sentence was suspended and he was placed on probation in 2001. He was discharged from probation in 2005. So the offense, the guilt remains unchanged by the trial court.
But the guilt of what changes?
It's the designation. I mean, if we see that historically, the court has authority to go back and either designate something a misdemeanor as a felony without placing somebody back in twice in jeopardy for the same offense. The offense and the conviction remain unchanged. I think that, to answer your question, certainly the state potentially could have gone under 24. That was not the defendant or appellant's argument here. There was never an argument that the trial court had jurisdiction to do what it did, but that the state's request was untimely. So the first mention of Rule 24 is today. The defendant's argument in trial court was that the trial court lacked jurisdiction entirely to reconsider its ruling. And the way I read condos and the way that criminal courts have historically incorporated Rule 60B into criminal cases.
Have they done so post-1975?
So I think the most recent case I found, it's a case from this court in 1989. It's State v. Brooks, and it was incorporating, I guess, was then Rule 60C into the probation context. The probation court there terminated probation based on a mistake of fact. So it's a little bit more recent than the 70s. Obviously not as recent as a few years ago, but 1989, criminal courts were still incorporating that mistake of fact premise in Rule 60 into criminal proceedings. And nothing in Rule 24 or case law since has prohibited trial courts from having the inherent authority, so long as an appeal hasn't been perfected and so long as the order does not pertain to a sentence. And I think, the defendant's argument upon...
Or to a judgment. So if we disagree that, if we think that this does go to the judgment, then you would agree that Rule 24 would apply to it?
To be honest, I'm looking at Rule 24 right now, and I apologize for using the technology right now, that it applies to a judgment. It doesn't incorporate the the options under Rule 60, Civil Rule 60, for mistake, inadvertence, surprise. I mean, it's pretty broad in Rule 24.2 for newly discovered material facts, or the conviction was obtained. It almost reads like a post-conviction rule for the state, but I'm not sure that it would expressly incorporate the various reasons for under Rule 60B. Rule 60B seems to be a little bit broader than Rule 24.2. I do not believe that, the state does not believe that this order in any way impacted the sentence, and I think that's a crucial distinction in why appellant's argument fails. As I mentioned previously, the timing, the sentence was suspended a long time ago, and this order had nothing to do with the sentence. I think the application of Civil Rule 60 will inherently be very in limited circumstances. Mistake, inadvertence, excusable neglect, all of the factors, potential avenues for relief under Rule 60, but because it cannot be applied once a party perfects the appeal, or if it has to do with a sentence, its application in the criminal context will inherently be in very limited circumstances.
So the state has 5.5 months, anytime up to 6 months, to come in and revisit a redesignation to a misdemeanor. It's simply on the table for 6 months. It doesn't matter. There aren't finality concerns with that from the state's perspective. It's just a fair game. We can wait and see if something else, if we come up with something different.
No, because I don't think Rule 60 would apply just for, and I know the defense appellant mentioned that in their opening brief, that this was going to be held over defendants' heads indefinitely. But there's a 6-month timeline, but it also has to be for very specific reasons that the trial court can apply Rule 60B. So just the fact that the state wants to reconsider something certainly would not be justification for applying Rule 60B.
We have a pretty well-developed system, and many might rightly argue overly complex system of rules that governs the timing of appellate filings after a conviction. All those rules are pretty intricately tied together. If we just reached back to 1925 and said, common law kind of lets us wing it. Don't we undermine the integrity of those rules?
I don't believe so, and I think had the trial court in this case denied the state's motion to reconsider, the state forfeited its right to appeal. So by that 20 days from the final order is jurisdictional, so the state doesn't get to appeal the denial of the motion to reconsider. And in that regard, almost limits the application of Rule 60B more.
And would then limit the application of condos? Because, I mean, that's an interesting take.
I don't know what the procedural timing for a state's appeal was at the time of condos in 1925, but the state's position in discussing this case was that, the state forfeited its right to appeal from the original order. The trial court granted the motion to reconsider. Had the trial court denied it, the state would have no. It's analogous to, I think it's Rule 24.3 that allows a trial court 60 days to change a sentence, but the state's position is that doesn't enlarge the jurisdictional time for the state filing an appeal. Mm-hmm. So if the state doesn't file a notice of appeal within 20 days, the trial court can still reconsider the sentence, but I don't believe that enlarges the jurisdictional time for appeal.
I think you're right, and I think there is within what you're saying an important point. I'm not sure I'm doing a good job of extracting it, but it still sounds to me like there could be a circumstance, unless you're saying that 20 days is binding, notwithstanding condos, then condos could still create circumstances where we are entertaining issues after the rules contemplate. Unless you would agree that the rules governing appellate jurisdiction overcome or trump condos, that might be the answer.
The latter would be the state's position in that, we see that historically if there's a suppression order, the state might file a motion to reconsider, but there is a bunch of case law talking about that doesn't enlarge the jurisdictional requirement of the notice of appeal, and I think that similar circumstances are present here, which again inherently limits the application of the rule. So the state won't, to Judge Catani's question, just wait 5.5 months as a matter of course to raise these issues because we've lost the right to appeal from that original order. But I don't interpret anything in 24 or condos as barring what the trial court did in this case.
In that case, do you feel that we have to talk about that?
I think, as referenced earlier, that double jeopardy concerns were not implicated at all by that's the state's position.
Well, I'm a misdemeanor and suddenly I'm a felon. I mean, that seems to implicate those concerns.
Well, he was a felon, and an order was designating him at a misdemeanor based on a mistake of fact, so the order just put him back in the position that he originally was. Of course, with the opportunity for motion in response time before the trial court. So the state's position is that this did not implicate jeopardy concern.
But up until 6 months, but then you're just saying jeopardy never comes into play. It's just you have the 6 months under condos because there was a mistake of fact that we've now corrected.
Correct. I don't think jeopardy. In condos, it's a United States Supreme Court case that's cited in condos. It's Bronson v. Schulten. And that case kind of goes through kind of some of the limits for that doctrine, and it would apply to facts that were determined by a jury, or perhaps if there's a bench trial and the trial court was acting as a finder of fact. Those are the circumstances that would bar under, I think, the double jeopardy prong.
But how is that different? I mean, it hasn't the trial court made some factual findings, and it's now reached isn't it? You're saying it's not a new judgment. This is completely different from a jury verdict or the judge acting. Isn't the judge saying there are no facts out there that prevent me from redesignating this as a misdemeanor?
There's factual considerations under both of those scenarios, but one gets to the judgment of guilt, and the other one here is a post-judgment order, which clearly affects the substantial rights of the defendant. But it's not like the trial court was hearing evidence and taking testimony and making factual findings, and then the state's going sideways through Rule 60B to have that factual consideration reconsidered. I think the trial court was very clear here that had it known about the pending 2017 matter, that the order would never have been granted. And that's exactly the type of circumstance that historically at common law and since 25 in Arizona has been, that avenue for relief has been afforded to litigants for the trial court to have authority to reconsider its own rulings that way. If there are no further...
Well, as a structural matter, the argument's interesting, but it has kind of a frightening slippery slope component, doesn't it? I mean, if we have rules that people rely on, and courts declare themselves free to find the right result by following their inherent powers, isn't that incredibly risky?
I think it encourages litigants to be forthcoming, and whether or not this, it's immaterial whether this defendant was committing fraud on the court, but by not updating the court about the 2017 matter, he ran the risk of having that order set aside for mistake of fact, or any of the other potential avenues in Rule 60.
Is the defendant put on notice at some point? You've got to update what you've submitted?
Not on the form, but I think we would agree that had that application been filed by an attorney, there would have been ethical obligation to update the court about that intervening 2017.
And you're saying the defendant has the same ethical obligation?
The state believes that he should have updated the court, but I think the court doesn't necessarily need to decide that to be able to say that without being forthcoming, regardless of whether he had a duty to be forthcoming or not, by updating the court, he ran the risk of that order being set aside once the true facts were made known to the trial court. And I think that's exactly what happened in this case.
So this is all on the defense, the defendant, and without any consideration for your office's failure to timely respond.
No, Your Honor, and so certainly there are probably were things the state could have and should have done more timely in this manner, and I think those are factors the court can consider when deciding whether to afford relief under Rule 60B. But certainly no, it was not just the defendant's obligation in this case to present that information.
And why isn't that, what possible explanation to say that there's some obligation to notify a particular attorney in the county attorney's office? Why isn't providing a notice, what's the basis for excusing kind of not figuring that out? We're just saying you don't have to figure it out for 6 months under condos, and so it seems like with electronic data systems that we have, docketing system, it seems like it shouldn't be that difficult to have a system in place to figure out if someone who's filed an application, there are pending charges against them, and there's obviously an opportunity to respond, and it seems like that's docketed somewhere in the state's and the county's system.
Certainly, and the state's not asking for, I think the record is clear that the assigned prosecutor did not personally receive notice, but that state is not asking for that to be an excuse. It's not the defendant's fault that Maricopa County's attorney's office is so voluminous and we get dozens of these every month, and so it's not the defendant's fault, and that's certainly not the state's position here. But I do think that those factors, like the delay and bringing that to the court's attention, can certainly be relevant in the trial court's discretion when deciding whether to afford Rule 60B relief. And the trial court here went through that analysis and still found that her original ruling was based on a mistake of fact. For these reasons, if there are no more questions from the court, the state asks that this court affirm the trial court.
Thank you, counsel. Rebuttal.
Thank you. I have a sense of how to approach this. In this particular case, we don't need to get to the substantive issue quite yet because there are a couple of issues that we can get to prior. One is the issue of timeliness, which we've kind of addressed, but I want to make sure that we capture. We can either apply Rule 24 and suggest that it usurps Arizona Rules of Criminal Procedure 60 in the condos application, and in which case the state failed to meet its timeliness burden and thus ends the state's position and we go forward. If we go down the slippery slope of condos, and I understand where the court's going, where rules are kind of thrown out, I assume that the state's position won't switch when it's cutting the other way, and when defendants who are late to file a particular position, appellate briefs, appellate memorandum, are now using common law from the 1920s and the infancy of our state to kind of bring those to bear, That being said, even if we do apply the condos in this case and we patch it in as a stopping point, the problem really becomes the condos is actually limited in Arizona case law by both McElvey and Sam, both of which said this doesn't apply to sentencing. In those particular cases, it limits the application of condos to particularly this exact situation.
How are you saying his sentence has changed?
So that leads me directly to the second point, which is the state's position is, and I'll quote from their brief, the designation of an undesignated sentence is not an imposition of a sentence. It says that on page 12 of their brief. There's no authority upon which it cites to say that, and that is in itself an unrecognizable position or untenable position to take in any circumstance. This is not just a designation of a sentence. This is the culmination or continuation, the end point of a sentence. And once it is done in this particular case. It is a sentence, and therefore the McElvey case is directly on point, limiting Condos' application in this particular case.
So you're saying the redesignation as a misdemeanor is a resentencing?
It is a continuation of the sentencing. It is the culmination of the sentencing. It is the end of the sentencing. The defendant comes forward and says, I've been granted the ability to potentially have my case if I dot my I's, I cross my T's, I make my application. We go forward, we can say that. It is the culmination of the sentence when that designation is made from a felony to a misdemeanor. And that kind of dovetails into the substantive conversation of whether or not double jeopardy attaches. But I don't even think we have to get there because the state's argument fails on both of those two forthcoming pieces. The first being that to suggest that the designation of the record has nothing to do with sentencing, has nothing to do with the entering of judgment, is itself an untenable position to take. The second of which is timeliness is the factor here. We need not get even that far because the state's failure to meet its timeliness burden, either under Rule 24, which we would suggest would be the controlling law, or in this case, if we do the Condos application, the kind of stopgap measures, Sam and McElvey stopgap Condos' application in situations just like this.
I apologize, I don't have Sam in front of me. What was the change to the sentence in Sam?
Sam cites McElvey in particular. Sam's a little bit more complicated in as much as it's more just a wrap-up case. McElvey is the one that's directly on point, and it says, we inferently, although not directly, limited the doctrine laid down in the Condos case by stating that at common law, where a defendant has entered upon the execution of a valid sentence, the court has no jurisdiction, even during the term at which the sentence was rendered, to set it aside and render a new sentence. In short, I mean, the Sam case was where the defendant was convicted of first-degree murder. He appealed. There was a simultaneous, so while on appeal, there was a simultaneous motion for a new trial based on facts, and the court was determining whether or not the lower court lost jurisdiction when a valid appeal was made. And Sam basically re-argued and kind of recompartmentalized how Condos would apply in criminal law and limited that down to particularly exclude situations just like this, highlighting the McElvey case, which was where the defendant was sentenced to jail, then another order, curtailing or shortening that sentence was implied. They said you can't do that.
But it's interesting though. There's one sentence in Sam that rewrites the holding of Condos, and I'm not sure I'm interpreting it correctly. But it says what we should have stated, awfully candid for the court sitting just 3 years later, was that paragraph 600 applied to civil as well as criminal cases insofar as the power was exercised under the common law. If that is the rule, can you help us understand what they had in mind?
Yes, exactly. So the common law application would be for mechanisms that were still provided under common law. And not statutorily usurped is how I particularly read that. But in its application, in Sam's application,
Is there any common law left in Arizona criminal law? I was under the impression we had constitutionally abolished.
it did. There is no common law. I don't want to get going. I feel like I'm going to be going down a particularly
Could you just give me a little more background on, you're saying the sentence was changed in McElvey. How was it changed? It's a reduction in the amount of jail time?
My recollection is it was during Prohibition, a alcohol transport case. The defendant was sentenced to 9 months and then an additional time period predicated off of the amount of money he paid. He could buy a day for $1. And at some point in time, I think there was a copper mill that had some influence in town that approached the court and got a reduction in sentence. And in McElvey, the Court of Appeals said in that particular case, the lower courts are not, once sentence is passed, once judgment is done, it's over. You can't apply condos in this particular situation to change the sentence.
So,
and in that case, it was a limiting factor.
So, counsel, I want to ask you something slightly different, and it goes to what opposing counsel said. I think she said that the redesignation of the sentence of the judgment from a felony to a misdemeanor doesn't alter the judgment. Do you agree with that?
Not at all. And the state starts with that as a presupposition for the rest of its opinion. And there's no authority upon which to grant. I couldn't disagree more. I think there's nothing more foundational than the designation. It's the culmination of the sentencing. So the Open 6 has this open-ended sentencing for a prolonged period, potentially indefinite period of time, where a defendant is sentenced to as a felon with the opportunity to get a misdemeanor. Once that misdemeanor is designated, that is the continuation, the culmination of that sentencing.
But if there's no change, has there been when the court declines a request to redesignate it as a misdemeanor, has there been a change to the sentence?
Yes. When the court declines, there's plenty of case law to suggest when and how and under what scenarios the court can decline. But when the court declines, the sentence is reimposed. It's basically reaffirmed. So when the petition is denied to designate it a misdemeanor, it similarly is the culmination, the continuance of the sentencing, in as much as a trial court can say, no, you did not earn the ability to not have your felony designated a misdemeanor. So it itself similarly puts a period or end of sentence on that. I have 46 seconds. Does anybody have any additional questions?
Not
That
seeing
we
any,
rest.
counsel. I think we recognize that we've raised an issue here this morning that the parties were not necessarily expecting us to raise, perhaps, although you're certainly knowledgeable about Rule 24. We're going to give you each the opportunity, if you choose, to submit a supplemental memorandum limited to 5 pages on or before February 26th on the applicability, if any, of Rule 24 to the facts of this case.
Did Your Honor say 5 pages?
5 pages or less. We encourage people to be efficient. And those will be simultaneous. No response, reply, or further briefing. We'll consider those upon receipt and then issue a decision in due course. With that, we are adjourned. Thank you.